Hello, my name is Andy Pavord. I'm the president of the American Association for Budget and Program Analysis. I would like to welcome you to today's budget panel, which will discuss the presidential impoundment of appropriated funds. We have a great panel of speakers. First, Doug Christatello will discuss impoundment from the perspective of the 1974 Budget Act and other history. Next, Eloise Pasachoff will discuss the constitutionality of impoundment. And then Chuck Kiefer will discuss impoundment from the perspective of Congress. So let me first introduce our panelists, and then Doug will start our discussion. Doug Christatello is a research fellow focusing on government program integrity at Arnold Ventures. Previously, Doug served as the executive director of the Golub Center for Finance and Policy at the Massachusetts Institute of Technology, where he led research and educational initiatives aimed at improving financial decision-making by government officials. He also served in the U.S. government at the Congressional Budget Office, the Office of Management and Budget, the Small Business Administration, and the Department of Housing and Urban Development. He is a fellow at the National Academy of Public Administration and a strategic advisor to government executives at the Partnership for Public Service. Eloise Pasachoff is Agnes Williams Professor of Law at Georgetown University Law Center, where she specializes in the administrative law of federal funding. An award-winning teacher and scholar, she is a public member of the Administrative Conference of the United States and serves on the Academic Advisory Board of the Supreme Court Fellows Program. She is a former law clerk to Justice Sotomayor, the Supreme Court, Justice Robert A. Katzmann, Second Circuit, and Judge Jed S. Rakoff, Southern District of New York. Charles Kiefer has 44 years of intimate knowledge and experience in the federal budget and appropriation process, both in Congress and in the executive branch. He served as staff director to the Senate Appropriations Committee for Robert Byrd and Patrick Leahy, and for Chairwoman Barbara Mikulski, managing a staff of over 60 professionals, allocating and providing oversight over $1.7 trillion in appropriations annually. So now I'd like to turn it over to Doug to get us started.
Okay, yeah. So I'm just going to set up our conversation today, provide some high-level definition of terms that we're going to be using, give you a little bit of sense as to why the issue of impoundment is very much in play in 2025. So let me just roll through a couple of slides, and I'm going to hand it over to Eloise. I seem to be struggling a little bit here. Hold on a sec. Okay. So just, at a very high level, the U.S. budget process really operationalizes, brings to life our Constitution. So the Constitution, as I think everyone on this call surely knows, right, gives the power of the purse to the Congress. And the key statute driving the budget process is now 50 years old, the Congressional Budget Impoundment Control Act of '74, which really provides the fiscal framework for decisions that are made on raising revenues and spending, importantly. So, we'll be lots of references to the '74 Act here today, in particular, because Title 10 of that act is the Impoundment Control Act, and that specifies procedures to be used in instances of impoundment. So importantly, just very high level on the budget, the president, it involves both the legislative and executive branches. The president proposes a budget, Congress considers it, and then ultimately passes a budget. It's sent to the president, and if signed, it becomes law. The president has constitutional responsibilities to take care that laws are faithfully executed and carried out as Congress intended. So I think the key question that we're facing today is whether amounts provided by the Congress in appropriations law serve as a ceiling or a floor for budget execution, for the delivery of those services at programs, projects, and activities that the Congress had in mind. And we'll get into that throughout the discussion. Okay, so just to define a few terms, impoundment. I couldn't find a statutory definition of impoundment, but OMB describes it as any executive branch action or inaction that temporarily or permanently withholds, delays, or precludes the obligation or expenditure of budgetary resources. This comes from OMB Circular A11. Which is the guidance to agencies in developing and executing the budget. There is, so the talk of impoundment, right? This notion of withholding or not spending funds that have been provided by the Congress. There is a legal path for the president to impound funds, and it's specified in the Impoundment Control Act. The president can propose to rescind, to cut, eliminate, or reduce spending that's been appropriated by the Congress, or to defer spending by sending a special message to the Congress requesting either of those actions. And the Congress then must act on that in order for the rescission or deferral to be effective. Importantly, the request to rescind funds enjoys expedited legislative consideration on the Hill, in that only a simple majority is needed to pass the legislation, particularly important in the Senate. So it's filibuster proof. But if the Congress doesn't act on it within 45 continuous days of calendar days of continuous session of Congress is the term, then the executive branch is forced to spend the money. I also wanted to mention apportionment here because apportionment, OMB is required by law to apportion funds before an agency can spend them. So OMB, being part of the White House, plays a gatekeeping role between congressional directives and agency administration of budgets. That's really important to know, and I think we'll touch on apportionment during the conversation today. So why is this important today? Well, the Impoundment Control Act's been around, as I mentioned, for about 50 years. There were instances of impoundment in the nation's history, particularly, and I think it's safe to say most recently, before sort of the current situation, President Nixon was very aggressive in trying to impound funds across a range of agencies. I actually adjusted the $12 billion number that you see thrown around. It's about $80 billion today. So that would be a significant reduction in spending were it done today. The Congress reacted to that by putting in statute restrictions on what the president could do and a path, as I mentioned earlier, for the president to essentially impound funds in partnership with the Congress if a president chose to go down that route. This issue popped up with the decision to withhold some funds for Ukrainian security assistance. That was, and I put the quote from GAO in here. GAO concluded that OMB violated the Impoundment Control Act it was really a dispute over, from a very tactical perspective, it was a dispute over apportionments, right? At what point did the funds need to be apportioned in that fiscal year for the funds to be made available for Ukraine? But so I think that alerted the folks in the first Trump presidency that that there were some real limitations around apportionment and impoundment. There were rescission packages proposed in the first Trump presidency, but during the most recent campaign in 2024, the president campaigned on the notion of repealing impoundment controls. For what that's worth, I actually dropped a link in here to the campaign ad. There's a lengthy campaign ad talking about impoundment. I think there were quite a few inaccuracies and falsehoods included in that campaign ad. Because it's, there's a quote, look, I don't really want to get into the merits of a campaign ad, but I think there has been some misunderstanding about what can be done through the impoundment process and how it's been viewed through the nation's history. And this is one of those sort of misunderstandings I see play out when I hear people talk about impoundment. There's two very different types of circumstances that drive impoundment. One are just routine financial management actions. Agencies are out there, we have CFOs across the government who are in charge of administering agency budgets in a prudential manner. And there are opportunities at times to achieve savings and not necessarily to spend every cent that the Congress has appropriated. But I think you have to draw a bright line between efficient financial management and the second type of circumstance here, which are policy impoundments, right? Where the president has substituted his judgment for that of the Congress to decide, I am not going to spend money on that activity because I want to spend it over here, or I don't want to spend it at all. And I see these two things very much conflated frequently. And importantly, as I mentioned here, whenever the courts have weighed in on this matter, particularly since the 74 Act, they've regularly held the president has no power to refuse to carry out activities funded by the Congress, unless they infringe on very specific presidential authorities granted in the Constitution. This is sort of an interesting timing for this session in that just recently we've had funding put in place on March 14th to fund the government for the remainder of the fiscal year. There were folks here in Washington very concerned that impoundments were occurring since Trump took office. There was this funding pause memo that went out immediately. It was then rescinded. There's been allegations that funds have been withheld. I do think it's important to draw a distinction between operating under a short-term continuing resolution and full-year funding. So, particularly because it's an odd thing, like let's say the president followed the procedures specified in the Impoundment Control Act and proposed rescissions to current year funding before full year funding was in place. It's an odd construct, right? Because the Congress is trying to determine annual funding levels, and it would be asked at the same time to consider rescission. So I don't really understand how that would have worked. So I give the administration a pass, at least in my mind, for any funding delays that may have occurred during the CR. But now granted, it's a full year continuing resolution, but to me, that's tantamount to a full year omnibus appropriations measure. So now any deferrals or rescissions must follow the procedures laid out in the Impoundment Control Act. And then finally, the negotiations on the current year budget, I found interesting because there were folks that are saying, why are you going to pass a full year budget if we run impoundment risk? Well, I think that has to be sort of balanced with the notion of, well, if the government is forced into a shutdown, what are the risks in that instance? And there's lots of them, including the president enjoys some degree of flexibility in determining, you frequently hear this term, essential. That's not the correct term. I mean, it's actually accepted service during a shutdown. But I think we would have been opening an entirely different can of worms if we were trying to operate under a shutdown. Okay, Eloise, I am going to hand it over to you. I did have a couple of other slides in here highlighting some key court cases going all the way back to Thomas. I kind of got a kick out of Jefferson gunboats. It was not a precursor to Jefferson Airplane by any means, but that's all we had at the time. And then I think Eloise is also going to talk about GAO. So
thanks, Doug. So if you get out of your slides, I can share my slides.
Yep.
Perfect. Great. Okay, can you all see my slides now?
Yep.
Okay, great. Hello, everybody. It's a pleasure to be here. I'm Eloise Pasachoff. I'm on the faculty at Georgetown Law, and I am, my job here, what I was asked to do was to share the legal arguments on both sides for the current impoundment situation. So that's what I'm going to do. Okay, I have many screens open and I want to just make sure everybody can you all see me at this point?
Yep.
Okay, great. So I want to kind of set up what we are talking about. And the real question that the proponents of the president's impoundment powers are asserting right now is that there's an inherent presidential right to impound. And these are new arguments that are being made. And I think it's part of our shifting constitutional terrain with the Supreme Court being increasingly willing to entertain concepts that are getting broader to the idea of the unitary executive theory. And so that's, I think, the background that we're in is a shifting constitutional moment that is putting in a different light a lot of the things that everybody had sort of taken to be not only the truth, the factual truth, but the legal truth, as Doug just explained them. So it's my job to I'm going to walk this through kind of neutrally, I think, to just kind of explain the array of constitutional arguments and statutory arguments that are at issue. I'm happy to share views and thoughts kind of when we get to the roundtable side of things, but I take my task right now to just be a little more dispassionately laying out the ideas. So when we're talking about constitutional interpretation, we're usually talking about some combination of what does the constitutional text and structure require or mean? What does the history and tradition of practice tell us? And then what does the precedent, the legal precedent from the Supreme Court, from other courts, from other legal interpretive bodies, such as the Office of Legal Counsel in the Department of Justice, what does that precedent tell us? And so let me just walk through the kinds of arguments that are being made on these three grounds: on the textual ground, on the historical ground, and on the precedent ground. So as a textual matter, the proponents of the broad presidential impoundment power, who are sitting right now in the Office of Management and Budget, I'm about to sort of tell you the legal theory as written by the current general counsel of OMB. So the idea behind this strong presidential impoundment power is that if you look at a bunch of the clauses in Article 2, which defines the presidential power, and if you read them against kind of a maximalist view of executive power, gleaned from recent cases like United States versus Trump, which is read to be about far more than just presidential immunity, but which is read to really be about kind of gesturing towards unitary executive theory itself, you get to something like a presidential right to impound. Here are the clauses that they're relying on. So the vesting clause. The vesting clause says that the executive power shall be vested in a president. And so the argument here is that all executive powers are vested in a president, and part of the executive power includes thinking about things like enforcement discretion. The president gets to make the decisions about things like enforcement. You can't possibly enforce every law to the full extent, and that's the executive branch's job and the president's job, really. And so the argument here is that spending or impoundment questions are a little bit like executive discretion, that just as the president doesn't have to execute every kind of criminal law to the full extent, the president also doesn't have to spend every bit of money to the full extent. That's the argument that they get from the vesting clause. They then look at the take care clause, and they say that the take care clause allows impoundment because while the president does have to take care that the laws be faithfully executed, sometimes laws are in conflict with each other. And so, for example, they read things like the Anti-Deficiency Act that Doug was just telling us about as potentially causing a problem if you overspend. And so maybe you need to underspend so that there'll be enough money to cover all of the obligations down the line. And the idea is that it's the president's discretionary responsibility to work through how to take care potentially conflicting laws are executed. They then look at some clauses that assign particular responsibilities to the president. So they look at the commander-in-chief clause, which again makes the president be commander-in-chief over the armed forces, and says that this clause allows the president control in a day-to-day sense over the military, over operational readiness. And they point to things like if an appropriations law requires a tank to be purchased for $1 million. If the executive branch can buy the tank for less than $1 million, the president should be allowed to do that, and that nothing in the Constitution should prevent that kind of what they would say is an impoundment. The last clause they look at is the foreign affairs. It's more like a power, not just one clause. There's a couple of parts of Article 2 that point to this power. So the president gets to appoint ambassadors. There is a clause that says he shall receive ambassadors and other public ministers. And from this, they read a broader foreign affairs power that basically says, look, foreign affairs are complicated. If we have committed to give funding to some overseas country that then attacks us or that does something that runs contrary to US foreign policy interests, the president has to be allowed to impound or not spend that money. And so they read all of these clauses together to say that there's basically an inherent presidential constitutional right to impound that the courts really can't touch. On the other side, the argument is that all of this just overstates matters, that the take care clause really just requires the laws to be executed as written, rather than to further presidential power that's divorced from the law. This argument also suggests that if the president wants to be making adjustments based on efficiency, fine, but that's part of what you do when you're negotiating the budget laws or the appropriations laws, as Doug was just talking about. That, of course, there's going to be flexibility in operations. Nobody requires that money be spent on stupid things that are a waste of money, that nobody would suggest, like the buying the extra tank, spending extra money for a tank that doesn't need to be spent. But the question is, what do you do with that extra money? And negotiations back and forth with Congress are sort of the way to go. And that often typically appropriations laws don't put out money for a tank, but rather put out money for a policy goal. And that the idea is to achieve the policy goal. As for the specifics about the commander-in-chief clause and the foreign affairs power, the idea is that Congress maybe can't condition the president's inherent authorities over the army and over foreign affairs. But most of what the president does in the military space and the foreign affairs space does require extra money. So whatever the president could do without money, the president has to be able to do without Congress passing conditions on it. But once the president needs money to execute or effectuate any of the things that he wants to do with his with his particular Article 2 powers, that's when Congress plays an important role there. Also, those particular powers, the commander-in-chief clause and the foreign affairs power, this argument goes, have nothing to do with domestic spending. And so to the extent that there's an argument about an inherent presidential right to impound, clearly the domestic spending can't rely on those clauses. Okay, so that's the debate about the constitutional text. Let's talk about the debate about the history now. And so here the real question is, I'm not going to walk through everything, but the real question is just how do we understand the several centuries of presidential practice and congressional response to that practice? So we just really quickly saw a slide that Doug showed about this famous episode about President Jefferson not spending all of the money that had been appropriated for gunboats. And the proponents of a strong impoundment power say, perfect example. There was appropriated money. The president decided he didn't need or want to spend all that money. And so that's like a long history and tradition of presidential impoundment power. And so they go through basically the entire structure or the entire history of the government, and they find lots of examples of where presidents declined to spend the full amount of money that had been appropriated for all sorts of reasons, they say. So some were foreign affairs, some were executive branch management issues, some were kind of good governance, efficiency, some were policy-based, and many more. And so they've canvassed and they've come up with, a whole host of examples that they say stand for this proposition. They cite Charles Dawes, whose name you may know as the first director of the Bureau of the Budget back in the day. And they point to comments that he made repeatedly about how, where it's possible, the president, the executive branch should spend less money. The idea here, this is the idea that the appropriations are a ceiling and not really a mandated sum. Okay, so that's the argument that there's this long, unbroken presidential practice where Congress kind of maybe pushed back a little bit, but basically accepted it. That's that history and tradition argument. On the other side, they just look at the history and tradition and they read all the examples differently. So, for example, the gunboat example, they go back and they look at the statute and they say, okay, well, actually, there was an up to. The president can spend up to this amount of money on gunboats. So there was nothing mandatory about that at all. These aren't actually examples of impoundments. These are examples of president spending less than was appropriated, but where the appropriation language itself allowed that discretion. So it really, this argument goes, is just examples of faithful execution of congressional efforts. There were a few examples, this other side argues, where the president maybe did sort of assert some presidential power to impound, but generally ended up spending the money. So you should look at what happened, not at the blustering that presidents offered. And then they also point to other things that Dawes, the first Bureau of the Budget director, said, including, I'm going to read this to you because it's a great line. He said, much as we love the president, if Congress, in its omnipotence over appropriations and in accordance with its authority over policy, passed a law that garbage should be put on the White House steps, it would be our regrettable duty as a bureau in an impartial, non-political, and non-partisan way to advise the executive and Congress as to how the largest amount of garbage could be spread in the most expeditious and economical manner. So as you see, even the Dawes position, this opposing argument goes, was in favor of, we don't like what Congress is telling us to do, but we have to comply with what Congress wants us to do. Okay, the next set of arguments after text and history is about precedent. And here there's, again, just debates over what the legal precedent stands for. So there's a couple of big cases that you'll hear talked about. So one of them was the case Train versus City of New York. This is actually the only real full-on impoundment case the Supreme Court ever heard. It was in the early 1970s. It was heard right after the Impoundment Control Act was passed, but it didn't involve the Impoundment Control Act at all. It was really just a statutory argument, and the Supreme Court ended up concluding that the statute in that case required the EPA to spend the money. Interestingly, the administration, it was the Nixon administration, had abandoned at that point the constitutional argument it had initially started with. So the Supreme Court just didn't have a chance to consider it. And so the proponents of impoundment say, okay, well then this case law is irrelevant. because they didn't consider the constitutional argument. It's a narrow statutory case. It doesn't say anything about our big constitutional argument. The second case you'll hear people talk a lot about is Clinton versus City of New York. This is the line item veto case from 1998, where the Supreme Court struck down the line item veto as unconstitutional because laws have to be passed by both houses of Congress and signed by the president. And the line item veto allows the president to change a law by crossing things out in the law without having to go back through the process of bicameralism and presentment. And so the proponents say, well, this isn't really on point. And they find a line in the majority's opinion that says that they say where the majority refers to, I'm quoting here, the president's traditional authority to decline to spend appropriated funds. And so they seized that line and they say, look, even here in the line item veto case, the Supreme Court is holding out the possibility of there being some kind of traditional authority to withhold funds. And they point to the idea that the Scalia dissent in that case is really, again, a narrow point that isn't about impoundment. So the people who say there is not an inherent constitutional presidential right to impound read that case differently. So they read that line in the majority about the president's traditional authority to decline to spend appropriated funds. And they go back earlier in the sentence and they observe that the Supreme Court is rejecting the government's argument that that is the case in that sentence. So it's kind of like quoted out of context. And they point to, in the Scalia dissent, Scalia basically says we resolved the impoundment question. To the extent that the administration in this case is talking about impoundment, we resolved that in that 1973 United States versus, or City of New York versus Train case. So that's settled law for Justice Scalia. So that's how that debate kind of goes back and forth. And then the last thing I'll raise on the president line is this Office of Legal Counsel, OLC opinion from the Department of Justice, where William Rehnquist, before he became Justice Rehnquist, before he became Chief Justice Rehnquist, worked as a senior official in the Office of Legal Counsel. And so he published an opinion that said, again, I'm going to quote, with respect to the suggestion that the president has a constitutional power to decline to spend appropriated funds, we must conclude that the existence of such a broad power is supported by neither reason nor precedent. So the proponents of a strong executive power observe that Justice Rehnquist did say that, but then they discount it. They say, on the one hand, he's a congressional apologist, and he always has been. And so we really shouldn't take that too seriously, because we're now talking about a strong executive branch theory that he kind of was not on board with. And also in that opinion, he did leave some possibility open for the commander in chief or the foreign affairs potential. And so we should kind of think about that. So as you can see, there's just a big debate, right? This is a new debate. This is all based on the contemporary moment of constitutional openness that we're in. But this is what's going on with these new debates and why they're coming to the fore now. Okay, I want to just say a couple of other things about what this might mean about the Impoundment Control Act, and then I have one more little slide on statutory stuff, and then I'll stop. So if you buy the proponent's argument of the strong executive presidential power to impound, then obviously the Impoundment Control Act is unconstitutional, because an act can't interfere with a constitutional authority. So you have to buy everything on the first slide in order to see that, but that's sort of the basic argument. Another view of the Impoundment Control Act, though, is that it actually doesn't ban impoundment. It provides an organizational mechanism where the president can actually decline to spend funds in conjunction with congressional approval, and that impoundment already is banned by the Constitution. So even if the Impoundment Control Act is unconstitutional, it kind of doesn't matter for impoundment purposes, because the real function of the ICA is to sort of facilitate the president's ability alongside Congress to decline to spend money, rather than being the thing that actually bans impoundment. Another reading of the Impoundment Control Act is that it's just a gloss on what appropriation language means. And by that, I mean this debate about whether appropriations language is a ceiling, or I don't like calling it a floor, because that suggests you can go above it. And the Anti-Deficiency Act tells us that you obviously can't. So I think of it as rather a ceiling or the mandated amount. And so I think, one reading of the Impoundment Control Act is that it just tells us that appropriations language is the mandated amount, because what Congress has told us is that if you want to not spend the mandated amount, you got to go through the impoundment mechanisms. Okay, there's two other aspects of the Impoundment Control Act, though, that the proponents of impoundment are using to say that the Impoundment Control Act is unconstitutional. So one of these has to do with the appointment and removal of the Comptroller General. There's been a big sea change in appointment and removal jurisprudence in the Supreme Court over the last decade or so, decade plus. And so that is sort of trending towards putting more power in the hands of the president. And so reading that precedent, the proponents of impoundment say that it's unconstitutional under the current version of what the appointments clause in the Constitution requires for the Comptroller General to be appointed by the president, but through a list proposed by Congress. And that removal, which is done under the statute by members of Congress, is unconstitutional because, again, removal authority under this newly developing line of cases is really supposed to be with the president as well. This is definitely relevant to what you are seeing in the news in the non-impoundment context about firing the NLRB and the EEOC and the MSPB. This is sort of part of that line of cases. So I haven't actually seen a lot of writing about this. So I don't know that there's any sort of strong arguments being made about the appointment and removal aspect of this. I guess sort of one thing I would just say on this front, though I haven't seen this written anywhere, is that if the GAO is actually a congressional agency, it's perfectly appropriate, maybe, would be an argument for Congress to have the removal power. The appointment power is maybe a little more complicated, but there's arguments that you can sever potentially problematic language and keep the statute as a whole afloat. Okay, and then the last potentially problematic from a constitutional perspective argument that proponents of impoundment make is that the Impoundment Control Act includes a statutory right to sue the executive branch to force the spending of what GAO would by then have concluded would be improperly, unconstitutionally impounded funds. And so proponents of impoundment say that that statutory right to sue itself is a constitutional problem, because it's not really, if GAO is an executive, is a constitutional agency, it can't really have executive enforcement authority, right? That's the executive branch. So that's one problem. The second problem is that legislative standing itself is contested. There's not really any Supreme Court decisions upholding the idea that a House or a committee of Congress can sue. There's some lower court decisions to that effect. And the GAO lawsuit standing could fall into those lower court arguments potentially, but that's more of an open question. There's only one lawsuit, one decision to completion where the GAO brought a lawsuit and its standing was contested, and it actually lost that lawsuit. There were reasons why that lawsuit might not extend to all of the context, especially not in the Impoundment Control Act context, but nonetheless, that's a complexity that's out there. One other thing, this isn't really about the constitutionality about the Impoundment Control Act, but it is, I think, an open question that's been floating around in the litigation over the new administration's actions, is whether private parties can sue under the Impoundment Control Act, or whether the Impoundment Control Act is just this mechanism for Congress and the president to work things out, where the only lawsuit capacity would be through the Comptroller General. So a lot of the lawsuits that you've been seeing are mentioning the Impoundment Control Act as background, but not many of them are relying on the Impoundment Control Act as being the source of the problem. They're really relying on the underlying statutes and the appropriations law that they say require the spending of money, again, regardless of what the Impoundment Control Act says. Okay, very few last things and then I'll stop. So GAO plays an important role in the impoundment context, and it has introduced a wrinkle in the clean statutory distinction between rescission and deferral that Doug walked us through at the beginning. And so they have developed this category that they call programmatic delay, which they define as one in which operational factors unavoidably impede the obligation of budget authority notwithstanding the agency's reasonable and good faith efforts to implement the program. And so I think a lot of these fall into the category of what Doug was calling the sort of ordinary efficient management of the government, right? Like not everything is a potentially problematic impoundment, but the line is complicated. And so as an example, famously, GAO determined that the first Trump administration's delaying spending by, not signing the apportionments for Ukraine funding as to the Department of Defense funds was an improper impoundment because there's no ability to substitute the president's priorities for Congress's priorities. But a couple of years later, it issued a separate opinion that looked at the Ukraine funding from the State Department that OMB was doing the exact same delaying of apportionment on. And GAO concluded that the state Ukraine funding apportionment delays were permissible programmatic delays. And they did so by looking at the language of the underlying statute. And so they said, in contrast to the DoD funding, where there was no choice given to the president and it was mandatory, not mandatory in the budgetary sense, but it was like required to spend. The state Ukraine funding actually had a lot of presidential flexibility in it. And so just a programmatic delay, not an improper impoundment. And that is then how they also, GAO said that Biden wasn't violating the Impoundment Control Act on delaying the wall spending because there were flexibilities in those underlying statutes that he was taking advantage of. And so what you get are arguments then that OMB is making that a lot of what they're doing is just programmatic delay. So with that OMB memo that Doug talked about where they froze all the money, that was part of the justification. These are programmatic delays. We have authority. We're just kind of looking at our underlying statutes. And I think that's why GAO hasn't issued impoundment declarations, because actually it's kind of hard to sort through all of that en masse. Okay, two other wrinkles and then I'm going to stop. So grant and contract terminations is a potentially backdoor way to doing impoundment, but in a possibly one by one permissible way. So the administration is doing, as you know, a ton of grant terminations and contract terminations, sometimes following proper procedures, sometimes not following proper procedures. But at what point does permissible one-off terminations constitute improper impoundment? That's a complexity that I think the courts are going to have to sort through. And then the last wrinkle involved in this is the personnel terminations. And so you have the complexities with that falling into the same category. At what point does possibly permissible, if they follow the right procedures under reduction in force, turn into impoundment? So, okay, this then turns to the role of Congress. Congress, it's really kind of on you. The courts can't do this all. A lot of our system requires political constraint rather than judicial constraint. And for that, I do have these sources that I'll share with everybody. We can share these slides out, but I will turn things over to Chuck at this point.
Yeah, Chuck, I guess the question is, how's Congress going to react to all this? Because the courts will have their reaction, but what do you think the Congress is going to do?
First, just a little bit of perspective, and then I will answer your question. To me, there is value in looking at the biggest picture. And for us, that means looking at the Constitution. You have to remember that the founding fathers who wrote the Constitution put their lives, their families' lives, their homes, their estates on the line because they did not want to have a king. And you have to remember that when you're reading the Constitution and how it is supposed to be implemented over time. Madison wrote in number 58, "The power of the purse may in fact be regarded as the most complete and effectual weapon with which any constitution can arm the immediate representatives of the people for obtaining a redress of every grievance and for carrying into effect every just and salutary measure." And that's why when you read Article 1 of the Constitution, it puts the power of the purse in the hands of the Congress and not the president. So in my mind, when the Congress acted in 1974 in the Congressional Budget Act to create the Impoundment Control Act, They did it, again, this was in the context of Watergate. They wanted to reassert Congress's power of the purse by creating a budget resolution and reconciliation process, by creating the budget committees, by creating the Congressional Budget Act, and by creating the Impoundment Control Act. This was an era when Congress, on a bipartisan basis, acted together to reassert Congress's power. You would think that something that created this tool called the Impoundment Control Act might have been controversial. Well, the Budget Act passed 401-6 in the House, and it passed 75-0 in the Senate, and was interestingly signed by President Nixon a week before he resigned from office. So in answering your question about where we go from here, it's important to remember the context of Congress standing up for itself on a bipartisan basis and asserting its power of the purse. This, as has been mentioned already, President Trump has taken a number of steps based on this assertion of unilateral power that I think easily can be read as violating the Impoundment Control Act. The examples, the actions that he's taken with USAID, firing half of the Department of Education, significant reductions in funding and staffing for EPA. Interestingly, on Friday, when the political parts of the country was focused on whether the government would shut down, President Trump signed an executive order on the 14th, essentially telling 7 different agencies to shut down. It did have the legalese language saying consistent with law, but clearly their intention was to shut these 7 agencies down. In fact, Voice of America, one of the 7 agencies, apparently has only been playing music since March 14th, and all of the staff was put on paid leave. So clearly their intention is to not spend money that was approved by the Congress and signed into law by the president. Interestingly enough, in each of the 7 cases where the executive order of March 14th tries to shut down funding, in each of those cases, there was explicit statutory language and funding in the FY24 Appropriations Acts for each of those entities. And of course, under the terms of the continuing resolution that President Trump just signed on March 15th, it says that each agency is supposed to operate at the FY24 levels under FY24 terms and conditions. So he wasted no time violating the law that he just signed on March 15th by taking steps to execute that March 14th executive order. The consequences for the Congress are going to be interesting to behold. I wish I would say that we were back in 1974 and we had a Congress on a bipartisan basis that wanted to assert its power of the purse, but that does not appear to be the case. The Republicans have lined up and voted with Trump each time it's been tested. And this long-term CR that the president signed on the 15th passes an incredible amount of power to the executive, something that hasn't been discussed too much yet, and I'm happy to go into more detail in the Q&A session. There is an absolute difference between bill language and report language. Bill language is the law. Report language is an expression of intent by the Congress on how the president is to spend the money specified in statute. In the continuing resolution that the president signed, there is no report language. And most individual, most activity on project level detail on how money is to be spent is normally provided in report language. But again, with no report language, in FY25, the president will have considerably more discretion on to decide how to spend money or not spend money. A couple of examples: EPA, the amount of money that goes to climate change is specified in report language. So there is no report language, so it would not be an impoundment if the president chooses to spend the money for EPA on something else in EPA. Now, if he doesn't spend it at all, that would be an impoundment. But every agency, virtually every agency of the federal government, the real detailed decisions are in report language, which are not law. And under this CR, the president will be able to be making those decisions in the next few months. And the CR has 45-day expenditure plan requirements in them, which means they're due by the end of April. It will be fascinating to see whether or not the president and OMB and the agencies decide to comply with those reporting requirements and provide detailed activity level decisions on how the president intends to use the discretion that is in fact available to him under the continuing resolution. Fundamentally, speaking as someone who was staff director on appropriations for Byrd, Mikulski, and Leahy, and lived through 20 years of detailed, very difficult negotiations on how to allocate, in the last few years, $1.7 trillion. The underlying premise of those negotiations is when the negotiations are complete and are reduced to text, either bill language or report language, that those decisions will be respected by the executive branch. And for the most part, they have been. And yes, Jefferson decided to spend less money on boats than was appropriated, but the law specifically said up to. So it was Congress giving the president the authority to spend less. It wasn't the president unilaterally asserting an authority to spend less. So I don't know how, in the current environment, Congress completes the negotiations on the FY26 appropriations bills, because they won't know at the point that these bills are being negotiated. They will not know whether or not President Trump will respect those decisions when he's directed by Congress to execute them. I'll pause there and happy to open it up to questions. Andrew, go for it.
There is one question in the chat. It says, "Can obligated but not expended appropriations be impounded?" I think that you would have to first deobligate the obligation through the normal deobligation process, and then it would be subject to impoundment. I think that's the answer. Is that correct?
That's my answer too. Although I would just say you'd have to go through the procedures of the Impoundment Control
Right.
Act. I don't really like calling things impoundments even, because there's a process. It's either rescission or deferral. So
Yeah, I agree with that.
but yeah.
And by the way, if it becomes an argument over whether or not the Congress is the wasteful branch of government, I would just note that GAO does do, at the request of the Appropriations Committee, a report on rescissions of appropriations. And since the Impoundment Control Act was enacted in 1974 until 2020, the last time GAO did this report, presidents proposed rescissions totaling $92 billion. And of that $92 billion, Congress enacted 25 billion of them. But over that same period, 1974 to 2020, Congress initiated and enacted into law $408 billion of rescissions. So the notion that Congress has failed in its duty to eliminate wasteful spending has no merit.
Hey, Chuck, can I ask you a question on the 26 process? Don't you think that Congress will have quite a bit more information in terms of how the executive branch has administered the 25 budget as they're trying to put 26 in place? I'm just by virtue of 8 months going by.
On the downside, they'll know more that things they care about are at risk. But I don't believe that the courts are going to be settling the major matters that are in play. I mean, if you're watching the court case, the Rhode Island case, for example, on them withholding funds, notwithstanding the courts saying you've got to make the funds available, not all the funds have been made available. And I am sure, and I think most of those, I'm not a lawyer, but I think most of the court decisions so far have been temporary restraining orders, and therefore the long-term decision by a higher court about the legality of what the Trump administration is doing probably will not be known. I'd like to hear from lawyers when they're making decisions in September. I think it's quite likely that decisions will not be made in September. We're not going to get the president's budget until mid to late May. It then takes another 6 weeks for CBO to score the president's budget. So I don't think we'll be seeing bills being marked up until June or July. I just think it's highly, highly probable that we won't see final 26 appropriations bills until Christmas, and at that point, they may not be individual or even omnibus appropriations bills. They may well be another long-term CR, because this president obviously is going to enjoy the discretion that was given to him by Congress with the FY25 full year CR.
So we've come to the end of the hour, but I'm willing to go a little bit longer just to answer a few more questions if the panelists, but if you have to leave, we'll respect it, because we do have some interesting questions. There is a reference that OMB has been using cancellation as opposed to impoundment. And then there's the suggestion that this is just their way of avoiding the term, so what do you think about that?
I think just as a legal matter, so impoundment is, I think, just not a legal thing, right? Like, I think we now talk about rescission and deferral. So nobody really talks about impoundment. The Impoundment Control Act got these two paths on the table. So nobody's going to talk about impoundment because that's not what the law says anymore. It's about rescissions or deferral. And my understanding is that cancellation is the statutory term for doing the same kind of thing, but outside the normal Impoundment Control Act process. So routinely, funds are canceled, but it's just not being done through the process of the ICA.
Funds are canceled. My understanding is after 5 years, then they're automatically canceled for liquidating obligations, right? That's the way I've always heard the term canceled used.
I think
that's true, but there's another consequence here that played out during Bush 43. During Bush 43, he did not want to use the Impoundment Control Act special message for rescission process, because he knew that if he submitted a special message proposing a rescission and Congress did not act on it within 45 days of continuing session, he was then under the ICA obligated to obligate the money. He didn't want to be forced to obligate the money necessarily, so he proposed cancellations, which brought a whole new perspective to the distinction between cancel and rescission.
Oh, interesting. Steve Redburn has a question about the administration has the option to propose rescissions under the procedures of the Budget Act. Will they now use this option for some or all of the amounts being withheld? Does anyone see that happening, and why or why not? I don't think they'll do it, because then they're admitting the Impoundment Control Act is law, and they don't think it's law. So
exactly, they're going to want to see this. They're going to want to test the theory that the president has unilateral authority to impound or cancel funds. So my hunch is that I share your view that they will not send them, notwithstanding Senator Graham's telling Musk that this was an authority that's available to the president and he should use it. No, I think they're just going to keep doing what they're doing until a court tells them they can't do it.
Another question, does the Fiscal Responsibility Act, as it relates, is that just done now? Because we have the CR and the CR is under, the spending level, I think, is under what was in the Fiscal Responsibility Act. So we're kind of done with that. Is that correct?
Not legally. I mean, the Fiscal Responsibility Act establishes a statutory cap on discretionary spending for fiscal year 25. So until fiscal 25 is over, that cap still exists, notwithstanding the fact that in both case of defense and non-defense, we are under that cap, but you still need to abide by the cap.
So that means OMB has to do the report on
Yep.
on the sequestration, whether it's needed or not. Yeah, okay.
Can I ask Eloise a question? Eloise, how do you respond to folks that ask you what the effect of repealing the Impoundment Control Act would be?
Repealing, I mean, there's the legal question and there's the political question. So, and I also think there's a distinction between repealing the Impoundment Control Act and striking it down as unconstitutional. So,
Okay.
I mean, I think my own view, right, which I was not really sharing before because my job on the panel was to explain the legal arguments on both sides. My own view is that there is no inherent presidential power to impound. So I think if you get rid of the Impoundment Control Act, you're still, it depends on if the Supreme Court strikes it down because it's unconstitutional or if Congress repeals it. If Congress repeals it, you're left with the same questions about constitutionality. If the Supreme Court strikes it down as being unconstitutional, I then think it depends on whether they strike it down as being unconstitutional because it interferes with the presidential power to impound, in which case we're done, right? Like, so my theory is wrong. But if they strike it down because the Comptroller General is improperly appointed and removal, I think then there's the question about if it's severable. So I think Bill Hoagland is asking a related question in the chat, is if the Impoundment Control Act is unconstitutional, would that strike down the whole Congressional Budget Act? And my strong guess is no, because there's a principle of severability where courts sort of retain what they could from the bargain that Congress struck while striking out the offending provision. On the other hand, there is a strong set of voices on the Supreme Court who think that severability doctrine is judicial lawmaking and so therefore is lawless. And so the people who are, the justices who are opposed to severability think that actually if something is unconstitutional, the whole thing ought to be struck down as unconstitutional. And that actually would, I think, take down quite possibly the whole CBA. So I think it just depends on how far they would be willing to go. And there is not yet a majority on the court. There's like 3 or something like that.
So isn't the Comptroller General appointment, is that specified in the 21 Budget Act, not the 74 Act? I thought it was the 21.
Yeah, the appointment of the Comptroller General.
Yeah,
the structure of GAO. That long pre. Oh,
that's from
1921.
Okay. Yeah.
Yeah. Oh, yes. The 1921 Act. Yes.
Right.
So
right.
if they were, right. No, the appointment. You're totally right there. So then, boy, that would then strike down a whole lot because that's the 1920. That's the whole presidential budget process. So boy, that would be really aggressive. So then, let me limit my comments before to the lawsuit, which I think is the more vulnerable one, to be honest, because of the questions about legislative standing. So yeah, let's take out what I said about the appointment and removal and put it in the vein of the legislative standing. If the court were willing to do that, to strike down the ICA based on that, but leave open the question about the constitutionality of impoundment, I think, that would be a layer of complexities that would then let that argument still fester.
So
and the
I
current
have one. Oh, go ahead, Chuck.
Current Comptroller General term ends at the end of this calendar year, so the whole appointment authority question is going to play out in real time.
Totally. This is not theoretical. Like, this is going to get teed up and be a big issue on the horizon.
Yeah.
So I have one question that's a little bit related, but in a couple of weeks, we've had a discussion about what would have happened maybe if the Democrats had shut down the government via filibuster in the Senate. And would it have been possible to put the CR in the reconciliation bill to avoid the filibuster? Is there anything that says he can't do that?
They would need to. I believe the parliamentarian would strike it down. The test in the past for the parliamentarian under the Byrd rule has been whether something is legislative and extraneous to spending and revenue decisions. And so much of a continuing resolution is unrelated. Sounds ironic, I know, because it's $1.7 trillion spending bill, but so much of it is not directly related to spending that I can't imagine that you could pull that off.
Well, you can't change the budget process either, right?
And that would be
Not
changed.
through
You
reconciliation.
could, if you were being evil, you could write a budget resolution that reconciles to the Appropriations Committee the authority to
Yeah.
do a CR.
Yeah, and I guess
But that
so there have been
still doesn't
discretion.
take them above the
Yeah,
Byrd rule.
right.
Or could they just
And-
do an appropriation, like just say they fund money for the agencies they favor? Like,
Well, and that happens. There have been appropriations provided through reconciliation. They're just scored as mandatory and not discretionary.
so you could have a mandatory funded Department of Defense or Border Patrol or something like that.
Yep. If it's budget resolution reconciles it to the authorizing committee to write it, or reconciles it to the appropriations committee, which I'm told there is one very minor precedent from like 1982 or something like that, but it is not the way it's been done for the last 50 years.
Sure. That's what we're hearing about a lot of things, I'm afraid.
Exactly.
Well, are there any more? One last question. Otherwise, we've gone 10 minutes over. I want to do first, thank you, panelists. This was amazing. I feel like we really privileged to learn a lot. And thank you so much. Second, I got to make a commercial for AABPA. I put a link in there to join our organization. It's only $45, but it helps us do these kind of events. We are a volunteer organization. There's no paid staff, but we do have some expenses. So if you can help us out by joining, it would be appreciated. The slides, I put the slides in the chat, but I will also put them in the LinkedIn page that we have, and I will be putting a video in the LinkedIn page. The video will be posted probably in a couple days because I have to figure out how to do it. But thank you so much. Last thing, we are going to have the next panel we have will be with Shelley Metzenbaum, Robert Shea, and Sarah Cunningham, and we're going to discuss whether performance budgeting, where is it going in this environment, if it still exists. So please look forward to an announcement on that, and look forward to announcements on other panels. And if you have an interest in a particular subject, please post it in our LinkedIn, and we'll try to find people to talk about it. Because we are trying to, I think these discussions are really important right now. I mean, this is real stuff that may fundamentally change the nature of our republic and thereby how we interact as citizens. So this is the big stuff. And I'm very pleased that we had 3 outstanding people to help us understand what's going on. So thank you. And with that, I'm going to stop recording and